afternoon, everyone, and welcome to this semester's Milia Lunchtime seminar meeting. This is a tradition that we started in 2022, showcasing the work that is being done within the Milia team. Today's session on abandonment and mining is being led and hosted by our postdoctoral fellow, Dr. Richard Cramer. And we have also two speakers, Dr. Bernard Kengni and Mr. Malcolm Combe from Strathclyde University. It is my great pleasure to introduce our host for today, Dr. Richard Cramer. Richard's doctoral thesis was on abandonment and regulated exit from property. So today's topic is really an extension of an interest that he has been harboring for quite a while, and we're talking about abandonment and mining today. Richard, I'm going to hand over to you without further ado.
Thank you, Henry, and good morning to everyone else, and thank you for joining us for today's seminar. Today we are engaging with the subject of abandonment in the mining context. The subject of abandonment has been of interest to property law scholars in recent years. The law in most jurisdictions heavily restricts the manner in which one may dispose of unwanted property due to the negative externalities that may result from unrestricted abandonment of unwanted property. Abandonment is particularly relevant in the mining context, given the thousands of abandoned mines litter the South African landscape, both historical and more recent. Few objects are perhaps a greater source of negative externalities than abandoned, unrehabilitated mines. These negative externalities range from being a severe drain on the public purse, to the attraction of criminal syndicates, to the impact on the health and well-being of the surrounding community as well as the environment. Abandonment in the mining context raises questions of property law, such as if and how one is entitled to abandoned mining land, as well as environmental law. How does the law address the impact of abandoned mine waste on the environment and mine-affected communities? There are also questions around whether rights to prospect in mine may be abandoned, particularly in light of the Mineral and Petroleum Resource Development Act's use of the term abandoned. What happens to mining land once mining has ceased is not only a question relevant to South Africa. Opening today's seminar will be Mr. Malcolm Combe, who will be talking about an interesting Scottish case concerning the abandonment of, or at least the attempt to abandon, land which had been used for coal mining.
Good afternoon, everyone, or good morning if you're still in Scottish time zones. I'm beaming in from Scotland today. As has been mentioned, my name's Malcolm Combe. I'm at the University of Strathclyde in Glasgow, and thanks very much for having me. Thanks to Richard for the invite. I'm going to talk to you today about Scottish land law, and specifically the abandonment of land ownership. So abandonment of land is something I've been dabbling with for a little while as well, including when I was on a trip to South Africa, supported by the Kengni Trust for the University of Scotland back in 2017. On my trip, I met Richard, who was so taken with the Scottish situation that he came to visit me in Aberdeen, where I worked at the time, and incorporated, as I understand it, the Scots law position into his own PhD research. Now, as such, I imagine Richard is perfectly able to give a nice overview of the situation in Scotland, but maybe he wanted someone with an authentic accent to do it. Speaking of which, I appreciate I have an accent that even some British people struggle with at times, so if I'm speaking too quickly, just say so and I'll slow down. So I'm going to actually begin my presentation with a mine in South Africa before I get to the mines in Scotland, but I'll also just say quickly that I've written some of this up in a short comment for the Edinburgh Law Review, co-authored with a former research student, also called Malcolm Rudd. So I'll give you the citation for that on a slide later. And also I spoke about some of this in an event for PropertyCon organised by Professor Bram Akkermans at the University of Maastricht back in COVID times. I'll mention a couple of other points today though, so hopefully I can at least add something beyond those. So in terms of my slide, as I say, I'm going to start in South Africa, and this is a Gold Reef City, which is an amusement park in Johannesburg, situated in an old mine. A fact that its operators have made into a theme for the theme park. And I took this photo myself, so no copyright issues, when I was on a bus tour of Johannesburg. I didn't go into the theme park. I can't review its Ferris wheel or anything like that. But anyway, this profitable use of a former mine offers some insight into what an owner can do with such a site. And in Scotland, we've actually got some interesting situations like pumped hydropower being used on old mine sites, and I think the same old mine site was used for an electric car rally recently. So there are some times where you can use a former mine site profitably, but as you well know, mining does not always leave land in a condition that allows such innovation. It can render land downright unappealing, so much so that owners simply want to walk away, literally and metaphorically, to the extent of actively wishing to have no further relationship with the land. And it's fair to imagine transferees for such land would be few and far between, leaving such owners with a limited number of options. So moving to Scotland now, this is Blair House in Fife, a local press story from almost exactly 10 years ago, actually. And this is one of several sites where the Scottish Coal Company Limited operated an open cast mining business. Its money-making potential as an amusement park, or indeed anything else, was not something the liquidators of the Scottish Coal Company felt they could capitalise on. So as we shall see, the liquidators who stepped into the shoes of the insolvent company thought the best thing that they could do for its creditors was to abandon the sites. The possibility of a landowner abandoning such land is something that was tested by those liquidators in court. So, having set the scene with those examples, and I'll come back to Blair House in Fife, I'll speak briefly about land in the generality, and then I'll set out some of the key legal questions that will be wrestled with today, and some of those questions are on this slide here. Richard asked me to keep to about 15 minutes. I suspect I'll be pushing 20, forgive me for that, but I'll see how we get on. So land, as I say, it's normally characterised and professionally valued as a desirable commodity. People who want it, they'll aspire to ownership of it, and those who already own land tend to want to retain it. If a current landowner wishes to rearrange her affairs and no longer own a particular piece of land, normally you'd transfer the land to an aspiring owner for a suitable price, and in a buoyant market, there's no problems there. But that won't always be the case. So environmental regulation may operate to render land of negative value. There might be a land designation that renders land use impractical or impossible. There might be fiscal reasons associated with ownership of land, so rates associated with domestic or non-domestic land. In an article for the Journal of Contemporary Roman Dutch Law, I won't attempt the Afrikaans pronunciation, there's titled Ownership of Agri Deserti During the Later Roman Empire, which some of you may have read by Rina van den Berg. She talks about things like exhaustion of soil, shortage of agricultural labour, and indeed barbarian hordes as reasons for abandonment in that era. But then it came back around to taxes. It's ever thus, isn't it? Anyway, barbarian hordes might not be as much of an issue now, but to what extent can a modern landowner escape the quagmire of ownership by unilateral action? That's the key thing, unilateral action. I have some other questions on the slide here, which we'll interrogate later. To foreshadow all of that, though, the answer to the second question, or rather, is it the second question, the third question? Sorry, I can't count. Following the 2013 Scottish coal case in the inner house of the Scottish Court of Session. So that's the second highest civil court in the Scots legal system, just below the UK Supreme Court. The answer to that question is no. And we'll talk about that shortly. And I'll mention also some interesting Scottish context at the moment, which makes this, as I say, quite topical. The first point I won't go into in any depth owing to time, but I'd be happy to talk about it in discussion afterwards if questions arise. Just in short, Scotland's engaging in some land reform at the moment. We've had our first land reform act was back in 2003, 20 years ago. There's been other things since then. And we've got various community rights to acquire land, including a right for a compelled sale where the land has been classed as abandoned, neglected, or environmentally detrimental. So Richard mentioned earlier one of your statutes and the usage of abandon in a statute. Here, I'm talking about this statute, not so much because the community right to acquire land is necessarily directly relevant to this talk. It might be interesting in the round, but it's more just interesting to show the limitation of the English language, where abandonment has a few potential meanings. And here I don't mean abandonment in the sense of the 2015 legislation. What I'm talking about is someone actively seeking to divest themselves of the land. So another couple of things that are maybe of interest at the moment, we're really trying to drive towards completing our land registration system at the moment. We've had an old deeds registry system for a long time, but we've got a modern register of title in Scotland. I'll come back to that as an interesting framing point later in the presentation. And I'll also mention a few things just for completeness. I'll talk about the law of positive prescription. I know there's a similar system for positive prescription in South Africa. So again, you'll probably know the main parameters of that. There's also something I'll mention at the end, which is potentially quite interesting for comparative purposes, which is a scheme that's been launched by essentially the public sector ownership that administers ownerless property, which is called the King's and Lord Treasurer's Remembrancer. I'll give you the full title later. And they've got a protocol called the Ownerless Property Transfer Scheme, which might be of interest for everyone, including me, because it's really, really new. So returning to South Africa, as I say, and in fact, returning to my host today, as I say, Richard and I met when he was a PhD candidate at the University of Cape Town. And I may have been partially responsible for making Scotland a comparator for his scheme, but he also had developed his research around law of Switzerland, and that was in a 2017 paper in the South African Law Journal. You all know about that, I'm sure. Richard certainly will. Richard flagged in his article urban environments where the poor state of the locale and unlawful occupation by those desperately seeking housing might make any land use by the legal owner difficult. And all the while, if that's accompanied by municipal rates or liability for dangerous buildings, that's going to compound the situation. So in Scotland, we've got some rules around dangerous buildings too, and I'll expand on some possible reasons that might lead to abandonment in Scotland here. On the right there is a slide, as a picture of a news report of a Scottish politician claiming there were some no-go areas in Scotland. That might have been a bit of a political point by a member of the Scottish Parliament, but that said, there are some urban areas where property values have fallen, and hyperbole aside, this could be a driver to abandon. Another possible point to consider in any jurisdiction is the rational economic reason for abandonment, which is to save in transaction costs. There's actually a saving by just going, well, I don't want anything to do with that. Now, obviously, the value of the asset itself might render such a saving unattractive, but in some circumstances it wouldn't. So there are two important questions related to the abandonment of land ownership, which I mentioned in an earlier slide. So is it possible to abandon land? And the answer to that now seems to be no, and I'll explain why later. But the overarching question is, should the abandonment of land ownership be permitted, with a sub-question of an appropriate mechanism for that? So in answering the second question, you get into all sorts of policy questions, and you get into the social obligation norm conception of ownership as formulated by Professor Gregory Alexander, which I know Richard spoke about in his paper that's on the slide there. So property rights allowing for human flourishing, things like that. You can also get into comparative law, and I know Richard considered Switzerland, where dereliction can largely allow for abandonment, and he obviously compared it to South Africa. I'm not sure if the position's changed since 2017. Maybe you can enlighten me on that in the discussion later. If I had more time, I'd maybe have mentioned important papers by Professors Penalver and Stralovitz, which I imagine anyone who's looked at abandonment will know about those. And there was a piece by Robin Hickey in the 2016 Conveyancer and Property Law Journal. I'll instead launch into the Scots law side of things now, which, especially in relation to land law, may have more in common with the Roman Dutch situation when it comes to land matters. So we'll get to that just now. And thanks for sharing that citation in the chat there. So in terms of Scotland then, I'll now consider the recent case that confirmed land abandonment is not possible in Scotland. So finally, I've got to the case. And the case is SEPA, the Scottish Environment Protection Agency, against the joint liquidators of the Scottish Coal Company Limited, which I'll now just call the Scottish Coal case. So why did these owners wish to abandon the land? So the liquidators found themselves looking after several sites where the Scottish Coal Company Limited had operated open cast mining operations. Incidentally, coal in the UK is largely a public sector entity owned to legislation, but there are situations where rights could have been acquired. Open cast mining tends not to be such a thing anymore, owing to planning law, but has been a thing in Scotland quite a lot in the past. So let's just take this situation as a given. And as I say, the Scottish Coal Company Limited had various sites across Scotland. They managed to sell some sites, but there was no market for others, such as the aforementioned Blair House in Fife. And the liquidators thought the best thing they could do for the creditors of the insolvent company was abandon the sites. They were basically shelling out some £500,000 per month, and the related funds could last for about 20 to 22 months. They had to stop water overtopping from the open cast mine sites. There was a lot of pumping of water, lots of things going on. So they wanted out. And in the outer house decision, so in Scotland, the hierarchy would get the outer house of the Court of Session, and then above that, the inner house of the Court of Session, and then a potential appeal to the UK Supreme Court. In this case, we didn't go to the UK Supreme Court, so the inner house decision is the leading authority here. Sticking with the outer house, Lord Hodge, himself a great and very strong property law mind, who's now at the UK Supreme Court as one of the Scottish judges there. So in his outer house decision, so that first instance decision, which was successfully appealed, Lord Hodge noted that council weren't able to find any authority which supported that an owner could abandon land in Scotland. And in the absence of specific Scots authority on the issue, Lord Hodge's decision drew in the Roman Dutch position, which he thought was to the effect of allowing abandonment. He drew on the works of Van der Merwe and Duval for that. He also noted the possibility of abandonment in Germany. That's at paragraph 22 of the first instance judgment. And these rules were taken to be applicable in an essentially civilian system of ownership like Scotland. So at first instance, as I say, this was overruled. He thought abandonment of property was possible, both land and movables. He said there was no reason in principle land abandonment should not be possible. If it's possible to abandon corporeal movable property, it should be possible to abandon land. But in the absence of a statutory regime, he wanted to regulate that. I'll talk about his scheme for regulation later, but for now it can be noted that essentially his scheme doesn't actually matter because his decision was overturned on appeal to the inner house. So here is what the inner house said. Basically, abandonment is not allowed. Lord Carloway gave the leading judgment from the three judges who were sitting there. He noted that ownership is a legal relationship and the law regulates when it can be brought to an end. So situations of an actual voluntary transfer, insolvency processes. But he also said you can't just transfer land into oblivion. So that was very much no, abandonment is not going to work. And he differentiated movables and immovable property. And as I say, there was no further appeal to the UK Supreme Court, so the authority stands. So in terms of whether the Scottish Coal case was the first to address abandonment in Scots law, it's difficult to prove either way. You're trying to almost prove the negative. I had a bit of a rummage. I asked my research student at the time, Malcolm Rudd, to look into it. And like Lord Hodge and like the council who addressed Lord Hodge, we couldn't find anything. There's some nice questions as to why there might not be much authority. This is covered in the Edinburgh Law Review piece, so gallop through these. The dearth of relevant authority could be attributed to several factors. We had the old feudal system in Scotland, which we actually only moved away from about 19 years ago. And the law that used to prevail in relation to Scottish land law was you had the crown at the top of the hierarchy and others in between, such that abandonment didn't quite create the same vacuum as you might see when you had a truly unititular setup. And also there were some conceptual difficulties with abandonment. I'll also talk about the law of prescription in a moment, which also played a role in feudalism. But now that feudalism's gone, it led to some nice questions about whether land should just be treated like movable property. And leading textbooks did adopt that position, but now Lord Carloway was saying no, definitely not. Another overarching reason why there might not be much abandonment in the case law is the law of prescription. This is difficult to abandonment, but it does occupy similar territory. So the development of the doctrine of prescription, positive prescription, as a result of a 17th century act from the old Scottish Parliament, it allowed for occupiers to obtain type of land after a 40-year period. The equivalent modern rules for us are found in the Prescription Limitation Scotland Act 1973, essentially allowing you to acquire land in 11 years. Now, prescription could be used in a feudal setting, so where you have that chain of feudalism, in a way that allowed for original acquisition of land by those higher in the feudal chain of the rights. So any abandoners lower in the feudal chain than anyone above, their title could just after a period of years be taken to subsume those lower rights. And in so doing, it prevented abandoned land being an issue that would arise in litigation. Also, and this is a much more practical point than the vagaries of feudalism that might be losing everyone, including myself, as I talk about it, it can reasonably be submitted that prescription would be more likely when an asset was of positive value, and it suggested that land would have been more positive, if that makes sense. You'd be less likely to have environmentally detrimental land prior to environmental law emerging as a discipline, prior to the excesses of the Anthropocene, prior to extractivism. So that mundane point possibly also has had an impact. So in terms of should abandonment of land be permitted, so in this regard, as I say, Professor Alexander's work, which I know Richard considered, in short, property might be viewed through the magnitude of the social obligation and the social function of the property, and ordering different kinds of property and the related burdens that may be placed in relation to that. Alexander's sliding scale approach might help to explain why some ownership entitlements exist in one context but not another. So why, for example, the abandonment of land ownership is permissible without many restrictions in Switzerland, but not elsewhere. In terms of how social obligation finds itself given expression in Scots property law, so landowners are protected against arbitrary deprivations or controls of their property, so expropriations and deprivations in South African terminology, so that's fine in terms of human rights law, but in some circumstances they'll have to forego certain entitlements of ownership. Thinking of an owner who wants out, though, a landowner's interest in abandoning property must be weighed up against other societal interests, particularly governmental budgetary constraints, and you need to have cognizance of the interests of the landowner too, so she might not have been responsible for the state of affairs that resulted in her property being a drag. Can landowners in such circumstances be expected to remain owners? If I had time, I might have quickly mentioned the law and economics point about inhibiting allocation of property to its most valuable uses and sort of getting in the way of successful market economies. Abandoned property might not have been the main focus of the paper that I mentioned there, the Posner and Whale paper, but as I say, forcing an owner to stay where they are might not be the best allocation tool for a resource. So sure, in Scotland, there is the possibility of positive prescription, which allows for someone to acquire land after 11 years, essentially, but why wait that long would be my potential argument. I'll talk about that in a minute. In terms of where Scotland sits, well, beyond the clear legal precedent for the impossibility of abandoning land ownership that we have, and there are sound policy reasons for the position that we have, because unrestricted abandonment would, as Lord Hodge noted in his own judgment, which thought abandonment could perhaps be allowed, he knew that it could be abused. And in that case, Scotland's no-go areas wouldn't exactly improve if abandonment was possible. But as I say, in some cases, the burden placed on a landowner might be such that compelling her to remain owner against the loss she is suffering might not be justifiable, or there might even be situations where it stops someone more suitable gaining access to an asset. So for talking's sake, it might be useful to consider what Lord Hodge suggested as a scheme in the first instance decision. So this is what his scheme for land abandonment was. I'll just let that slide speak for itself. But basically, there were various steps to try to make sure everyone involved in the process was suitably well prepared and well versed in what was happening. And at the bottom there, letter G, there's reference to that office that I mentioned earlier, which is now known as the King's and Lord Treasurer's Remembrancer after the ascension to King Charles III to the throne. So that, at the time, it was, of course, the Queen's and Lord Treasurer's Remembrancer. That body deals with bona vacantia, it deals with ownerless property, deals with the treasure trove, and it can have a role in relation to abandoned property, which I'll mention at the very end and come back to that. The other thing that Lord Hodge spoke about in terms of how his scheme came to pass, he spoke about where it came from. He tried to draw some analogies with some English insolvency rules which weren't applicable in Scotland, and he spoke about getting the keeper involved. But essentially, he was trying to make something work where there wasn't anything before. In the inner house, though, Lord Carloway giving the decision, of, as I say, that now stands, he makes clear, though, the only way ownership might come to an end would be actual destruction, so coastal erosion, dissolution of a company, the law operating to divest someone of land through debt enforcement, for example, or voluntary transfer. There is no other way out. That's the essential setup. So what should be allowed, and I know this is something that Richard wrestled with in his article and thesis, for my part, I'm not going to say there should always be a general right to abandon land, and there would be much to consider before introducing exit routes in specific situations. But I do think something else could be fashioned. I'd quite like something that's a bit like a speeded up positive prescription process, which might be appropriate if, say, a restoration specialist wants to take on land, notwithstanding its physical state or environmental obligations. And in such cases, I'd let them do so without having to wait for the 10 years of positive prescription and 1 year of publicity relating to the land registration rules. So maybe just speed this up and make it a 3-year process, for example. And just to show there are no good ideas anymore, there's nothing new under the sun, in Rena van der Berg's article that I mentioned earlier, Ownership of Agri Deserti, there was a look at Gaius, which allowed for usucapio of land and a special form of occupation in the provinces during the Principate. And then when it came to the later empire, you were able to, someone could come in and occupy land where they accepted fiscal requirements. They'd basically be treated as the owner. So there could be something there. Returning to Scotland, if there is someone who really wants to acquire land that really is abandoned to the fullest extent that Scots law allows at the moment, I think we should try and facilitate that. I think it's unfortunate that we try and hold that up, and it's in keeping with the land reform movements in Scotland to try and have some kind of faster process. Perhaps a subtly different scheme would allow for some kind of statutory declaration saying, come and get this land is free to a good home. Perhaps that's not really abandonment and it could evolve into a consensual transfer. But again, having a scheme like that, maybe it could allow for a more efficient tax treatment and as a bit of a driver to that. And this might also be good, I think, in the context of trying to complete Scotland's land register. So we're trying, allegedly we're going to do this by 2024, very unlikely, but we're trying to complete the land register. And if you could try and allow for some kind of system whereby existing owners who are a bit reticent about coming forward at the moment because of the state of their land would be happy enough to assist and help with that, maybe it would ease the process and lubricate the process a little bit. There would be things to work through in relation to a scheme like that. You need to avoid abuse of the process, abandonment leading from one person to a linked person, but there are rules and insolvency processes or current land reform situations that could be drawn on that might help there. Anything else to mention? Well, that was some of the land registration complexities I mentioned. There might be, as I say, the way we're trying to complete the land register at the moment, the keeper can try and force someone to register land. Maybe that might lead to situations where ownership is currently unclear being sort of unearthed, shall we say. So that could be interesting to consider. And then the other thing to maybe mention, two other things to mention. I'll mention practically what happened at this site, and then I'll mention other thoughts for the future. So in Blair House, the site where I started with, this has now been taken over by a restoration body. Actually, there was further litigation about this case involving a remediation bond that an insurance company was initially not paying, but they had to pay in the end. Lady Wolf delivered a judgment in relation to that in 2017. So remediation has happened here. Maybe my fancy scheme that I'm proposing isn't necessary if we manage to do something correctly or something eventually good that led to restoration of the land. But did it need to take as long as it did with all the various steps and what have you? And then some concluding remarks to mention. Just as I say, I'm going to mention this ownerless property transfer scheme, which is brand new. It's not been fully implemented yet, but where land has become ownerless because a company has dissolved or the true owner just can't be traced. There is now a scheme whereby this public entity, the Crown's representative in relation to abandoned property, will take that asset, and rather than just simply going, we don't want it, and disclaiming it, which they're allowed to do, they can speak to the local authority, they can speak to local community groups, and try and lead to a facilitated route to transfer. It's really quite an interesting scheme. I'm quite excited about it. There was a consultation ended in December last year, so that could be something to watch and possibly something to consider. And then also, we do have a new land reform bill coming along, so that's maybe just something to watch for the future as well. Conscious of time, I will stop talking now and stop sharing. So thank you for your patience and thank you for listening.
Thank you so much for that, Malcolm. That was a fascinating talk. As those who are familiar with my work will know, I believe a familiar position prevails in South Africa with regards to the abandonment of land ownership, that it's ultimately not possible to abandon land ownership in South African law. But in South Africa, we have a situation where the landowner and the right holder are not necessarily the same person, because under the South African under South African law, the state is custodian of the nation's mineral resources, which means the state grants rights to prospect and mine and land, which can be done contrary to the will of the landowner. So rather than go over the position regarding the abandonment of land ownership again in South African law, which I've done previously, I'm going to be discussing the possibility of abandoning prospecting and mining rights granted under the MPRDA. So in the mining context, when the subject of abandonment is brought up, we often think about the physical abandonment of mines, the 6,000 plus abandoned and derelict mines that litter South Africa, and which will take potentially hundreds of years to rehabilitate. But we often don't think about the abandonment of the intangible prospecting and mining rights themselves. While I cannot get into detail on the theory today, it is suffice to say that law of abandonment is a more complex topic than is usually thought. While it may be assumed one is free to terminate the ownership relationship with property as one sees fit, a closer inspection of the legal framework reveals the law, in fact, strictly controls how we may dispose of our unwanted property. And such restrictions can, in some cases, extend to intangible rights. In particular, limited real rights in land, of which prospecting and mining rights under the MPRDA are an example. It is a peculiar feature of the Mineral and Petroleum Resources Development Act that it mentions the possibility of the abandonment of rights granted in terms of its provisions. It has been remarked by academics such as van der Schyff that such a possibility is inconsistent with the Act's objectives. In particular, empowering a right holder to abandon a right granted in terms of the MPRDA's provisions conflicts with the significant responsibilities and obligations that attach to these rights. During the lifetime of the right holder may be required to increase the financial provisions set aside for rehabilitation of the land, among other obligations. And once the right terminates, the stringent mine closure obligations trigger. Section 56F of the MPRDA states that a right to minerals granted in terms of the Act lapses if it is abandoned, while sections 43 and 44 provide for the consequences of the abandonment of a right. However, what is not explicitly set out in the Act is how exactly one may abandon a right to minerals granted in terms of the MPRDA. Is it possible to even achieve this in terms of the Act's provisions? Section 107(1)(g) provides that the minister may make regulations concerning the abandonment of rights to minerals, but the regulations themselves are silent on the matter. To determine whether it is possible to abandon rights to minerals and how it may be achieved, it is necessary that we turn to Section 11(1) of the MPRDA. This section provides for the transferability and encumbrance of prospecting rights and mining rights. In particular, it sets out that ministerial consent is required for certain actions in respects of rights to minerals: cession, transfer, letting, subletting, assignment, alienation, or any other disposal of such a right. While abandonment is not explicitly mentioned here, it is the only reasonable interpretation of any other disposal, in my view, is that it includes abandonment. The word disposal would appear to be a catch-all for all acts other than transfers and encumbrances. If this section does not provide for abandonment, then abandonment is simply not provided for in terms of the Act, regardless of mentions elsewhere. It would seem thus that one simply cannot abandon a right to minerals and granted in terms of the provisions of the MPRDA. The consent of the minister is required for such an act. Furthermore, the common law would appear to act as a check on the abandonment of rights to minerals, given that prospecting and mining rights are classified as limited real rights. Common law rules that are not inconsistent with the provisions of the MPRDA are still applicable. Servitudes, an example of limited real rights, may not be abandoned where doing so would cause harm to the servient tenement, as per the authority of Duplessis versus Phillipstown Municipality. This rule would appear to be consistent with the provisions of the MPRDA, which, as I've noted, states that prospecting and mining rights are limited real rights. It would appear to follow that rights to minerals may not be abandoned where doing so would result in harm to the servient tenement, which would undoubtedly be the result if the right holder fails to comply with their obligations in respect of rehabilitation of the land. It would seem, in my view, that unilateral abandonment of rights to minerals is not possible in the legal framework created by the MPRDA. And the position is reinforced by the common law rule restricting the abandonment of limited real rights, where harm may result to the servient tenement. This ultimately raises the question whether abandonment is in fact the right word to describe what is envisioned by the Act when it refers to abandonment. It would perhaps be better to classify what is referred to abandonment in the MPRDA as a form of surrender, given that another party, this being the minister, has the discretion to accept or reject the conveyance of the right. And obligations attached to the right remain. Whether referred to as abandonment or surrender, the action only results in the extinguishment of entitlements, not the concomitant obligations. Surrender is a better term since the right holder must obtain the minister's consent, and the relinquishment of the right would likely be subject to the minister's conditions. Further, the term surrender would appear to better fit the consequences of relinquishing a right to minerals, given that such a relinquishment does not end the concomitant obligations. The term abandonment does not adequately capture the consequences of the termination of a right in this manner. Furthermore, unlike the operation of abandonment in the law of property, a surrendered right under the MPRDA would not simply become unowned and open to appropriation, but would once again fall into the custodianship of the state, meaning the minister would be empowered to award that right to a particular mineral on a particular piece of land to a future applicant. The surrender of the right directs it to a particular party, the state, for potential reallocation, which conflicts with the operation of abandonment in the law of property. The reasons one may seek to abandon a right to minerals granted in terms of the provisions of the MPRDA are not necessarily clear, given the substantial obligations that will continue to exist even after the termination of the right. Case law concerning abandonment under the MPRDA to date has involved a third party claiming that the right holder has abandoned its right, rather than a right holder seeking to enforce a right to abandon. There's thus a dearth of case law on the subject. Regardless, as I have suggested, ministerial consent would be required to give effect to an election to abandon a right under the MPRDA. In any case, the only true manner in which a right holder can escape its liabilities in respect of a right to minerals is to cease to exist, which unfortunately is all too often the case when mining rights are sold on to smaller, more financially ill-equipped concerns, thus leading to the proliferation of abandoned mines. Abandonment in the framework created by the MPRDA, at least abandonment in the true sense of the word, does not seem possible. As van der Schyff states, it would have been ideal for the legislature to have created a clearly circumscribed process through which a right holder may surrender its rights. I would contend, in line with van der Schyff's suggestion, that the word abandoned in the MPRDA be replaced by the word surrender, and that Section 11.1 of the Act be amended to include the word surrender as an act which requires ministerial consent. The suggested reform would have little to no substantive effect on the contents of the MPRDA and would serve to make explicit the position which prevails in the existing framework. It would also be better describe the legal consequences of the act of abandonment in the MPRDA. Ultimately, abandonment as it operates in the context of MPRDA reflects a wider trend in the law of property. So long as externalities may arise from the relinquishment of a particular right, whether it be ownership of movable or immovable property or a limited real right, the law will place restrictions on such a disposal. Rights granted in terms of the MPRDA entail not only entitlements, but obligations, which are onerous. The Act outlines the consequences for the abandonment of these rights, but such abandonment would require ministerial consent, and in any case is better viewed as a surrender of the right in question. I have published on the subject, and I have added the citation to my article there that was published in Obiter at the end of last year. Now we've covered the abandonment of land ownership in Scotland and the abandonment of rights to mine and prospect in South African law. Now we're going to move over to what are the consequences of the proliferation of abandoned mines for both the environment as well as mine-affected communities. And I'm going to hand over to my colleague, Dr. Bernard Kengni, for his presentation at this point.
Thanks very much for setting the stage. I'm glad that I'm not going to be looking at whether abandonment is right or wrong. I'm rather going to focus on what happens when abandonment happens, especially in the context of mine waste or mine tailings. And I'm doing this specifically on how this affects communities or society. It's a topic that I've been working with for the past 1 year, and this came at the back of my PhD, where I focused mainly on the environment, and I started questioning what happens when pollution happens, what happened to communities. And last year, when I went to a workshop in Gauteng, the West Rand, where I met someone who, Dr. Vusi Kosi, who is here in attendance, who became a collaborator, and we started discussing how we can look at how the law can resolve the health issues, or at least how the law can be used to resolve the health issues caused by mining or mine waste particularly. And so this topic has been on the head. And so going to look mostly at how this waste or how mine dumps, what the health hazard that it is for communities. And when we talk of communities in this context, you realize that it's mostly the poor in most cases. And so, and Richard mentioned earlier on about that we have about 6,000 abandoned mines in South Africa at the moment. And of that 6,000, you have more than even that amount of mine dumps scattered across the country. And talking of those mine dumps, you equally have hundreds of them directly close to human settlement. And I will share shortly what the type of health issues that this bring. But yeah, having people living very close, that's the challenge that we're having. And it's said that in Gauteng alone, just in Gauteng, I mean, particularly in the context of gold mining, it says that 47% of mine waste in Gauteng is gold mine. And I will tell you very shortly why I'm focusing a lot of gold mining, because that it brings most of the issues that people face when it comes to their health. And so with this mine dump scattered across the country, why do I find a problem with it when it comes to communities? It's because of things like this. If you can see, for those who are seeing my screen, it's because of things where you have communities like this living very close to these mine dumps. And that's usually where the challenge starts. And the thing observed across the country is that very often these dumps are not fenced. And I can tell you that visiting the West Rand last year, I observed that myself. These things are not fenced. Often, there are no signposting or security around those tailing dumps, at least informing communities that this thing is risky for you, or there's some danger here, or there's some form of radioactivity going, and such things are often missing. And I personally witnessed that myself when I went on a field trip. And equally, it's estimated that you have about 1.6 million people living in either informal or formal settlement directly next to these mine dumps, or to some of these mine dumps across the country. And that's a problem, that's a challenge. And why? Because now then you have people falling sick, because this mine waste come with its own issues, which cost, let me get there. Just some of the major ones, I have 5 of them, 5 of the major issues that communities living around this mine dumps are experiencing. And I say they're experiencing, not like something that is anticipated that will happen. They're experiencing, of course, there's always that challenge of communities then having to prove that indeed this sickness started here. Reason being that, as scientists have argued, including Dr. Vusi, whom I've worked with for quite some time, is that people move around. And sometimes they're not even sure whether the sickness started from these areas. And that's why very often they can't even get compensation, because it's difficult to prove that that's where they got it from. But like I said, I'm going to talk about 5 main aspects, or 5 main heavy metals, if you can put it that way, associated with mine dumps, and what the type of illnesses or type of health concerns they cause. So you have uranium, for example, which can get very radioactive in many parts. And I'm always mindful of this story I learned a couple of years back in a community, I think it was around Pumalanga, where there's a particular community where the number of children with physical defect were alarming. And so this group of people conducted a research which found just on the hair of those children, they realized that the level of radioactive or the level of uranium in the children's hair was in some cases up to 9 times higher than what is allowed for a human body. And we're talking about hair. Think about what could then be in the bloodstream. But so in the context of uranium, you have issues like cancer, and we're talking about liver cancer, lung cancer, and then often also cause kidney damage. And then you have on the other side, cadmium, which cause diseases like kidney problems, liver diseases, and nervous system challenges as well. And then there's lead, which also comes with its own diseases like affecting the nervous systems, causing cardiovascular disease, immunological disease, and renal disease or renal malfunction. And then you also have behavioral disorders. These are type of things observed very often in these communities. And of course, as I said, very often it's estimated or assumed that it's from there because the practitioners or medical practitioners or scientists can identify that what these people are suffering from is related to so and so metal, and it could only come maybe from gold mining, for example. And then you have arsenic, which causes its own complications relating to nervous systems, cardiovascular, respiratory, endocrine, immune complications, renal and hepatic systems. And then the last one, but not the least, is particulate matter, which obviously leads to issues like respiratory and cardiovascular diseases. And so having this ailment, these are type of things these communities are struggling with. And the main challenge that they then face is that often they don't get the right treatment. Very often they don't get the right treatment, obviously also because they're not covered by the same law that covers people working in mining. I mean, in the Mine Health and Safety Act directly covers people working in the mining company and not these people from outside who then have to attend general hospitals and often daycare hospitals, which are not always well equipped to pick up at early stages of cancer or respiratory problems. Unlike people working in the mining context, where if someone gets up, if a mine worker in the coal mining industry, for example, gets up in the morning with a cough, the mine hospital will screen them for possible TB or possible signs of TB or respiratory disease. With these communities, it's not the same. And so the question that we as lawyers will often ask is, then what does the law say about this, or where is the law in all this? Well, the law is there, as imperfect as it may be, but there is. But of course, we have to understand that these things, most of these mine dumps existed way before these laws. Some of these laws we're talking about came into play. So it wasn't there to stop it, but of course, it can always repair it retroactively. But that's it. So you have Section 24 of the Constitution, which provides the right to a clean environment for everyone in this country. And then it takes you down to the National Environmental Management Act, Waste Act, which says how mine waste should be managed and gives clear instruction on how government should go about dealing with this thing. And under there's this one called norms and standards, which these are basically standards of how land, for example, should be taken care of to avoid pollution, even down to water pollution as well. I'm focusing here on the main issues main environmental issues that come with such abandoned mine dumps. Now, on the other side, because there's always dust issue and so on, then you have the Air Quality Act, which clearly provides how this mine dump should be managed such that the air around it is clean for communities living nearby, and which the Air Quality Act itself provides for priority areas. So this is mainly something where, for example, the minister responsible for environmental protection identifies that a particular mine dump in a specific area has become problematic. The act gives the minister that power to declare the area a priority area, which means it's an area that should be prioritized for rehabilitation, for some form of zoning, or at least to make sure that the problem, the specific problem or challenge that is coming with this mine dump is addressed. And this is just to name a few of the pieces of legislation that and how, what the law is doing. But the main question, which is something I've worked a lot on with the, lawyers often look at the same ways. Also always, what is then this? If this law is there, what is the problem? Why is it not doing what it should be doing? And as always, there's the issue of implementation. And well, implementation, what I've observed so far, it's not necessarily because government doesn't want to implement. It's rather related to some aspect of its inability, which range from capacity, lack of sufficient capacity to deal with these issues, all the way to even the type of technology that is needed or whatever they need to implement this. And when I talk here of implementation, it's mainly about government actually fixing the problem, because in most cases, and I think Richard mentioned that in most cases, the people who created the problem are nowhere to be found. And it's estimated that this rehabilitating these mine dumps is going to cost government billions of rand. And the rate at which the rehabilitation is going, it might take hundreds of years, and this problem might not even be cleared totally. And so that's the type of challenge government face to even make sure that the law comes in and get this rehabilitated the way it should be. And then you have issues like compliance and setbacks. So when I talk of compliance, I'm mainly going to just say here, maybe compliance on the part of government, complying with what it should do. But if you think of mining company, there's no company anywhere in most cases to force or to push to comply with the law and rehabilitate. So it's mainly government. And then the setback, in terms of setback, it has mainly to do with illegal mining, which often illegal miners come on the side where rehabilitation has started, and then they go in to help themselves. And as a result, they often damage what has already been done. And this then means sometimes the process has to be started all over, or sometimes be halted for a long time and sometimes indefinitely. So that's one of the things. And then there's that aspect of the law and policy making, which is sometimes has been termed as not catching up with reality, that we have laws providing for one thing when the problem needs a new approach, a new dimension. And I'm going to give you one example. At the moment, talking in relation to communities, mine dumps are not expected to be more than, they should not be close. Well, they're supposed to be, the gap, or what they call exclusions, or the gap between from the foot of the mine dump to where communities start or properties start. It's not supposed to be less than 100 meters. But of course, we have to understand that these dumps have been there a long time ago, and some of these communities were there long ago. So it's not a problem that government has created, except that government can then help communities to move from these areas to move forward. And something I personally observed when I was in the West Rand last year is that even active mine dumps still have communities living very close by. And the argument is always that communities come and settle there on their own. And let me make a disclaimer here, not all mining companies are not, some are really trying, and there are even mining companies who have tried to make sure that these exclusion zones are about 500 meters upward. Some are talking of about 1,000 meters, except that experts argue that even the 1,000 meter is not enough. It should be minimum of 1.5 kilometers. Communities should be minimum of 1.5 kilometers away from mine dump, because of dust can travel very far. Water pollution travels very far, and then the aspect of illegal mining going into illegal miners going into the site also has to be dealt with. So this is something that the law hasn't really kept up, providing for 100 meters when it's nothing. It can't even protect the community or doesn't give enough gap to create a bridge between community. I mean, to create enough gap between communities and mine dumps such that they are safe from this issue. And so that's the sort of challenge that the law is facing. And with the law not being able to do that, one thing that brings to my mind is this aspect of human dignity, which, I mean, it's a big issue in South Africa. I couldn't miss this one, leave this one out. The question for this community, and immediately, if you were to travel to one of these areas, immediately you look at what is happening, even the conditions in which this community live, and then you are told how toxic the dust coming from those dumps is. You immediately think, then where is the dignity of these people? Yes, but let's put the fact straight that very often these people, they come and stay there on their own, be it out of ignorance or because they want to earn a living, and that's an argument also. We know land is an issue in South Africa, so sometimes some of those communities some of those people living there is the only place they can call home. That's one challenge. And then you have the aspect of earning a living, talking about illegal miners, people who want to go in there and help themselves. They want to earn a living. But I will talk a little bit more about that as we progress. So looking at all this, one thing I've been working on with the other colleagues and so is, what is the way, what is it that if we were to say, let's reform the law, or let's speak to lawmakers or to people implementing, what is it that they're supposed to do that doesn't seem to be done as it should? And I've placed this into two categories: short-term solutions and long-term solutions. And the short-term solutions, they're basically these three, where one argument I'm putting forward is that monitoring has to happen more than often. And I can honestly tell you that when I visited the West Rand, it became very clear that not enough monitoring was happening. And this, I had people from government who admitted it themselves. They were not doing enough, or not, in some cases, don't even know. Until from one community, there are voices of people complaining about respiratory issues, and then proactively, they then come in to start checking what is happening. And then there's the aspect of community awareness, which some mining companies are doing it, actually putting some signposts. But when you speak to some of these communities, they clearly tell you neither government has been here not government or the Department of Health, whoever, has been here to go maybe door to door and speak to us in a language that we can understand, that this thing is a hazard for you. Of course, some communities have heard that. And based on this, another aspect is usual to say, if this is very dangerous for your well-being, then you have to relocate. And that is one big issue also. Big issue, why? Because often members of communities, like I said, for some of them, this is their only home they know. And when they're asked to relocate, the question is where we are going. What about our source of living? Are we going to have a source of living? What's going to happen there? And so some people are reluctant to go because they argue that we are being taken to a place which is even more remote, and we wouldn't have access to something that we can live on. And then there's also the issue where maybe you have about 100 people living in an area, and then government starts planning how to relocate them. Maybe a land has been demarcated already for where they'll be relocated to. While government is busy working on this, and it takes maybe another year, and by the time they're ready to move the people, the number had increased. You've had more people come into the community, and then government realized they've demarcated land for 100 people. Now you must accommodate 200. Then they can't really do it. But still, it's something that government can still do. But I'm just highlighting the challenge that then comes with having to convince people that where you are going, it's going to be better. That's what they want to hear. Where you are moving me, you say, I'm sick here, but I'm earning a living here. Where you're taking me to, will I get anything better? Secondly, new people coming in brings an added challenge. And then I mentioned the issue of health facilities earlier, where one thing I'm thinking government should do immediately, which I'm holding it very dear to my heart, is that these communities suffer the same liver issues, renal issues, or respiratory issues that people working in the mine may be faced with, except that they don't have the opportunity to get the same treatment, the same attention when it comes to looking after their head. Where I read a case where someone, he was eventually diagnosed with, I think, renal issue, and he has been to their clinic, and he said they've been giving him Panado to go just say it's a pain, and until it was diagnosed. But in the mining context, that won't happen easily, except the mining company is very negligent. Otherwise, there are things that are picked up very quick, because if you complain of a problem in your chest, you are screened. You're not just given an inhaler to go home. You are screened to really make sure it's nothing to worry about. So these are things that I think in the short term could be done, while the lawmakers think of how to make this even work. But like I said, the big issue is finances, which the Department of Mineral Resources and Energy says that money is nowhere. They have to still look for the money. And then the long-term solutions, which I try to argue that these have to be innovative. The solutions have to include innovative strategies and must include multi-stakeholder engagement. And I will explain in this next slide what I mean by what I think the innovative and multi-stakeholder could be. So this will entail bringing these innovative strategies to rehabilitate those mines such that it becomes safe for people, even people living. And so the first thing I thought about, or that I came across, is containment and isolation. So, but this is a short, this could be long-term, but it can be a permanent solution. And it's also very costly, but it's mainly about, however, maybe using concrete or whatever to cover something that can cover the mine waste permanent, at least for a long period of time, to stop things like dust from flying around. If possible, stop water from coming in contact so that it then pollute water stream and so on. And so the main purpose is to prevent the spread of pollutants. And then on the other side, you have remediation, which I think Malcolm mentioned that, which is always one, every time you hear about mine waste, you hear the term remediation, which is mainly about treating mine waste, which some companies are doing, but now I'm referring to abandoned ones. And this is something that government is going to have to do. And it's being very costly. Why? Because the technology to do it is very complex. And it's in three phases. You have the chemical technology, chemical remediation, biological, and thermal. All these are scientific terms. Because of time constraint and because of the scope of this, I don't want to go into detail, but this aspects of technology that have to be taken into account, which are complex and expensive. And I think this is one thing that the Department of Mineral Resources and Energy is struggling with. Then there's recycling, which can happen, and it has been proposed that that this mine waste can be mined again to extract what is still usable, so that then reduce what is left. And then there's building materials. And I learned in the last workshop I went to in Gauteng with the Department of Mineral Resources and Department of Health, and they said there are companies trying to make bricks out of mine waste, especially gold mine waste, except that some companies are struggling because it's not then very profitable, because they have to first treat it in case it's radioactive or something. They have to also protect people working in, because the challenge is not to try to save this waste by converting it to something commercial and then exposing people working in the area to radioactivity and any other sickness that could come with. Then land remediation. And this takes me to a project that we've been working with, also Resilient Future Community of Practice, which through Professor Mostad here, I've been involved, had the privilege to be involved in that project for the last 3 years or so, where the idea is that we use revegetation, plant place plant or put plants on this mine waste so that it extracts heavy metals from the ground. So first of all, the first idea is usually just plant any vegetation so that it stops dust from flying around. But this project, this COP, is particularly looking at a specific type of plants that have the capacity to extract heavy metals from the ground. And that's one aspect. And I think that project is still going, and it has the prospect of succeeding. And this is one of the areas where we say multi-stakeholder engagement will have to work. And through the COP, we also realize that there's a lot of legal barriers on how to make those things work, because some of the plants considered either invasive or legally not allowed in South Africa to farm. So those are areas where we're also struggling with, and that's where I think law and policymakers have to come in and work with this COP or just about every expert involved in this thing and see and work with on what is possible and what type of policy can make it work. And then you have recreational facilities, which it's strongly believed that mine waste could also, or mine dump area could also be converted to recreational facility. And I saw Malcolm mention one, and I was very happy to see that. I haven't seen that before. And that's something that government can also consider, or create room in the law to allow private stakeholders to look at this. So with all this, in conclusion, my stand is that having communities next to mine dump, it's an issue. It's an issue, particularly in South Africa, where there's a very big divide between the poor and the rich. But it can be resolved. It can be resolved. And it can only also be resolved if the same poor who sit in that area, even though they know the risk that is for them, are offered a better alternative. And I remember Professor Nick Olivier, who once said to me that the poor find themselves in certain situations because they can't feed themselves. If we create an environment where they can take care of themselves in an alternative way, they wouldn't be risking themselves. And while waiting for government to resolve the problem or to find the billions that are needed to repair or to rehabilitate these mine dumps, maybe communities should be given an alternative so that they don't see these areas as the last option for them. And I leave it there. Thank you.
Thank you so much for that, Bernard. It was really interesting to actually get an idea of what abandonment in the mining context looks like on the ground, and its impact not only on the environment but also the local communities. We have a few minutes left for questions.
To what extent do you think there should be a division in terms of abandonment between property law as a whole and insolvency law? Because obviously in a system like England, they rely on insolvency mechanisms to allow for disclaiming property, so abandoning land and other types of property, in a way that doesn't ordinarily apply in the normal property context. And I wondered about the extent to which that is valuable, providing some sort of a gatekeeper function. So it stops parties abusing the abandonment of land somehow, because you have this third party taking control and following all the relevant mechanisms and so on.
Thanks very much, Alistair. But it's a couple of juicy questions that say thanks grudgingly. No, I think on the insolvency side of things, it's a really interesting point. And obviously, in the Scottish Coal case, there were a few sort of jealous glances cast to the south at the scheme they had there. I actually think it's relatively attractive to go down a sort of insolvency-esque route as a, if we were to embrace it. That is obviously, it's a big question if we were to do so, but I think that does bring in a degree of control, and in a way that's probably what Lord Hodge was trying to do in the first instance. I can see some merit in that.
In relation to Malcolm's point about the use of prescription, I wonder what the advantages of that would be in comparison to the system that you could have, whereby if a liquidator did have the ability to, I mean, on Scots law, they do have the ability to transfer land to someone else, including, for instance, a community group, for nothing or for very low amounts of money. Of course, the issue there is that if there are ongoing statutory licenses requiring cleanup or decontamination, then that is going to put off such parties from obtaining the land in the first place. So I don't know how you would get around that, whether you use prescription or just rely on the normal method of transfer of land by a liquidator. So I'd be keen to hear your thoughts on that.
In the South African context, actually, the most important case concerning abandonment involved one party who was arguing that he had acquired the property through prescription, and the state arguing that the land had been abandoned and thus became bona vacantia and fell to the state, because the owner had left South Africa decades before. But otherwise, there isn't really a lot of intersection of prescription and abandonment in the South African context, because prescription takes 30 years here. So very often you don't really see a lot of intersection of abandonment and prescription.
If there was a route through insolvency that allowed for this to happen, some kind of pre-pack process might be a quicker route than prescription, or even my turbocharged prescription suggestion. So yeah, there probably is a degree of further thought there. So thank you for that. It's put me on notice of something else.
At the heart of the law governing abandonment of property is the difficult distinction between lost property and abandoned property. So I just want to hear from you, in your pursuit of thinking innovatively about possible law reforms that can help the situation, have you given some consideration and thought on how best, whether it's a doctrinal methodology that we can use to best manage this distinction and make it much more simpler? Because I believe if we can have some working approach to differentiating a lost and abandoned property, then crafting a fit for purpose law of abandonment will be a much more easier exercise than it is so hard at the moment.
The lost versus abandoned property split, and I hope I'm not dodging the question, but I suspect it's more relevant to the movable side of property than immovable. So in Scotland, lost property, the rules don't engage in the same way because someone hasn't actively, unilaterally sought to remove themselves from the ownership situation. And in Scotland, there would be statutory rules in relation to lost property from our scheme is in the Civic Government Scotland Act 1982, if you want to look that up. In relation to abandoned property, again, sticking with the movables, if you own property, both your own land and movable property, and this is something that I think Stralowitz says in his article, when you're abandoning your property, you're purposefully putting it on someone else's land, and you're trying to get rid of it. Normally, it would just be the situation of ascertaining as best you can someone's mindset for both the animus as well as the physical act of what they have done, and then if you can establish that, then you can go, right, well, this is abandoned. And then if it's abandoned, you then go straight to, in our case in Scotland, the King's and Lord Treasurer's Remembrancer, who deals with things like bona vacantia. But if it's lost, then you've got a scheme that involves the local police, and then statutory rules that allow for, if it's unclaimed after a certain time, then maybe the finder can come in, or there might be a public auction or things like that. As regards loss in the sense of land, I don't think it quite works in the same way, because either it's a case of there is an owner and you maybe just can't quite contact them, but there's still an owner, and then there might be different ways of dealing with it. But I suspect in that situation, then the law of prescription might sort of rush in and allow someone to change what is the de facto situation into the de jure situation in due course. Again, though, if it's truly abandoned, it's a sense of someone who's trying to, as the liquidator of this company was, then we're into the rules that I was discussing and what Lord Carloway said in his case. I hope that answers your question, Matiba.
My second question relates to your presentation, Bernard, and is in relation to clearing of the exclusion zones. You suggest that the government having the role to enforce compliance with the exclusion zone regulations, for instance. You suggest that communities, mine communities that are located closer to those mining operations, they may have to be relocated if it becomes hazardous or dangerous for for them. So I just wanted to ask, I mean, it's quite a problematic suggestion, that one. Yes, it's very much convenient, because then once they are relocated, then we have solved quite a number of issues that may flow from that. But then it's a very problematic solution. In actual fact, my PhD thesis actually grappled with the very same topic of resettlement of mine-affected communities. I was so surprised how many nitty-gritty issues flow from that, from compensation, from stakeholder engagement, who needs to be involved, who must incur all the finances that would flow from that relocation process. Have you given a much deeper thought on how exactly this relocation is to unfold on the ground, and who is going to sponsor this? I know in most instances, if it would be the mining company, but now if it happens, if it is the government that is pushing for relocation to happen, who will then finance this kind of a relocation?
It's a burning issue. And I'm going to take you back. When we went to West Rand, it was a whole group, and it's called GCRF Mine Dust and Health Network. That was a group from the engineering guys, and they pulled me in from the law side, and they were. So one thing that we discussed around the table was that it's a massive problem, and even only government alone cannot deal with it. And this we picked up when you have normally in a specific municipality, the local government will be responsible to relocate people, because it's also the duty of the the local government in terms of its service provision to always also look after the people. And then we realized that, first of all, some municipalities don't have the budget to relocate people. Some that have it have other priorities. And we had people arguing, especially from the Western administrator around the Western, arguing that we have many things to deal with, that relocating people, it's a big challenge on its own. And so some of these municipalities argue that it will be because of the massive involvement of capital and then looking for alternative land, that should be the national government. And you have people from the national government on the other side feeling very strongly that these are things that municipalities should deal with. It shouldn't become a national issue. But eventually, when we left that workshop, one main agreement that we came to was that it should be a multi-stakeholder thing. Then government has to go back and work on legislation and policy and see how you can allow private individuals or institutions like the COP I mentioned, how you can allow them in to play a part. So for example, if I own a company and I think that I could use that mine dump maybe to make bricks, for example, I should have an exchange with government to see what part I can play with government to relocate the people. I could cover a part of the fee and maybe deduct it from my tax, or somehow government, we should work that out. Or I could come out openly and say, okay, as part of my deal for government to allow me to do this, I'm going to take care of relocating the people who are at risk. I think we have about 600 abandoned gold mines alone in Gauteng. Can the local government in Gauteng deal with that? It's difficult. I personally think it should be a multi-stakeholder thing with both local and national government and private participants like organizations who have the know-how. Even mining companies were invited, and some of them during that workshop pledged that, no, if government opened the doors and let us in, we all have, because they are business, they also have to see what do we gain when we come in to rehabilitate mines abandoned by other people, because these are orphan mines. We don't know who the owners were. So if someone who's operating a current mine has to come in, what are they gaining in it? So that's where government needs to make some concession and allow others to come in and help it. That's the idea, help it so that we can move forward together.
Don't you think that it's a good idea maybe to have a rehabilitation fund like in the Western Australia, where mining companies would all contribute to that rehabilitation fund, and that rehabilitation fund as well would go out there to actually try and rehabilitate any mines irrespective, thus making sure that now in terms of maybe their financial provision that they are putting aside would be maybe lessened.
Mining companies have always argued in South Africa that if we're going to put, we already putting money in a certain fund that will be used in future. So maybe this is something that you want to suggest. Should government consider changing the law? I mean, the state or the legislature should consider changing the law such that instead of mining companies putting money in a certain trust, they should put it in this fund that can be used and not only designated for that specific mining, but should be put together in a particular fund so that instead of government waiting for a certain mine to close in 30 years' time and we use this money, why can't we use it now to fix the immediate problem? Then in 30 years, what we have at that stage, we use it to fix the upcoming problem. But of course, this is something that one has to study, bring on experts to study then the challenge, because sometimes you look from one angle and you like a friend of mine will often say, you fix an immediate problem and create a bigger one in the future. So those are things to balance.
I would really like to thank Malcolm and Bernard for setting aside the time to present today and for making this seminar really fascinating.
From my side, also a thank you to all three the speakers, Richard for hosting, Malcolm and Bernard for being available, and for this fascinating conversation, and also for everybody who came to listen. Thank you very much for your contributions. It's lovely to see your faces.